renowned experts on this issue who fulfill different roles in the ICANN system and who have very strong opinions about privacy-related issues one way or the other. So since we've started late, I'll keep my comments very brief, and I'll just tell the order in which the panelists will go. First off, we'll have Michele Nalen. Second, we'll go Paul Diaz. Third, Monica. Fourth, Richard, sitting here to my right. Fifth, Stephanie Perrin, and then, fifth will go Ciara, and then Stephanie Perrin, and then Joy. Each of our panelists will make very brief remarks right at the beginning, introducing their points of views, and then we'll have an open discussion, bringing in the audience and myself. So without further ado, Michele.
Thank you. Michele Nalen. Just before I say anything else, if I speak too quickly, wave madly or something, because I have, no, you behave, Rafiq. I generally have two speeds, which is either ridiculously fast or or even faster. Just to explain who I am, I'm the founder and CEO of Black Knight. We're an ICANN accredited registrar based in Ireland, which also means that realistically speaking, we're a hosting company. Within the ICANN space, I happen to be the chair of the registrar stakeholder group, though I am not speaking in that capacity. I'm also on the board of the Internet Infrastructure Coalition and various other entities and organizations and things. To kind of put this in context, what we're talking about here in this session is to do with GTLDs, so generic top-level domains. So that's com, net, org, infobiz, plus all the new top-level domains, such as .ninja, .social, and things like that, which of course we sell. If you want any, you go to our website. We are not talking about country codes, so we are not talking about stuff around, say, .fr, .de, .co.uk, or any of the other countries. ICANN does not have control over policies involving country codes. The entire thing around privacy and ICANN policy really came to a head with the introduction of the 2013 RAA. The RAA is the contract between registrars, in other words, companies like mine, and ICANN being the Internet Corporation for Assigned Names and Numbers, which is a California-based non-profit, yada, 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 who have a kind of overseeing type role with regards to names and numbers, though we only really care about names. The contract mandates the information that registrars such as ourselves have to collect, and also mandates a certain amount of data that we have to display in what is known as WHOIS. It also mandates how long we are meant to hold on to that data, which is of course ran slap bang straight into various things which other people on this panel are better qualified to speak about than I am. The other thing as well to understand is that WHOIS as a concept, I mean, it's a directory, it's a way to get information about which entity or which person a resource has been assigned to. I mean, originally this started out as being something to address a purely technical issue. So you had a network operator in one part of the world, a network operator in another part of the world, and if there were communication issues between the two networks, it would be really, really useful to know who the hell to yell at, ring, or whatever to sort out those problems. Over time, the WHOIS has evolved, and depending on who you are, you will use it for a variety of different reasons. And there's an entire debate and debacle about what it could be used for, what it is used for. In the IP address space, there is WHOIS as well, and that has evolved quite a bit over time, but is probably more limited in scope in that it's primarily dealing with a technical resource. I think that kind of covers everything I need to say. Thanks.
Thank you very much, Michele. Paul?
Okay, good morning, all. My name is Paul Diaz. I'm the Vice President of Policy at Public Interest Registry. We are the GTLD, the generic top-level domain operator of .org. We currently also operate 3 IDN versions of org and hope to soon bring to market a new TLD for non-governmental organizations, so NGO, and the Romance language equivalent ONG. Like Michele, I also serve as an executive committee member for the registry stakeholder group. I'm the alternate chair, and before working for PIR, spent about 12 years at Network Solutions, so I have registrar experience as well. To help further kind of frame and begin to paint the picture here, Pranesh asked me to speak briefly about the difference between thick and thin whois. I think a lot of our discussions today will be focused on whois, just to make sure everybody understands, except for 2 legacy TLDs, COM and NET, that operate as a thin model. Everybody else operates as a thick registry operator, or thick whois operator. What that means is that the registry has a responsibility for publishing the information that appears for the names under their management. That data, however, is provided by their accredited registrars. So in my case, .org, Michele's firm, Black Knight, will push to us the contact information that is required under our agreement with ICANN to be publicly posted. In the GTLD space, you can have privacy and proxy registrations as well. So information is published. It may be my personal name, address, etc., or if I've subscribed to a privacy service, you may see my name or not, and in all likelihood you would see contact information for the provider of that privacy service. It creates a lot of confusion down the road. We'll probably tease it out in the discussions, but just understand thin versus thick basically means the registry operator is responsible for publishing the authoritative source, as opposed to a thin model where you go to the registrar anyway. But ultimately, that contact information is collected by the registrars, not the registries. And that leads to a lot of customer service questions from my organization, folks asking, I need to get in touch with so-and-so because they're doing something in a .org, and we have to refer it because we don't have that data. We are not the original collector, just the publisher. Also has to make a note about, and we'll be careful about acronyms, I sign a contract with ICANN that's called the Registry Agreement, an RA. Registrars sign a accreditation agreement, a Registrar Accreditation Agreement, RAA. In turn, they will have a side agreement with us. Another acronym, it doesn't matter. The important one for our discussions today is the RAA. There have been 3 flavors over time. The original ones dated to 2001. All of those have subsequently been overtaken by either 2009 or more recently 2013. Very importantly, and again we'll get into more detail, there was a push from parts of the ICANN community, drove ICANN to negotiate with the registrars to update, and what ultimately we got in the 2013 version. That RAA has additional requirements, verification, light requirements, but they're in there nonetheless. Also pass-through obligations. In the past, resellers who are not contractually bound to ICANN could be used as a loophole for certain obligations. That's been addressed in the 2013 to some degree or varying degrees. Very importantly, the 2013 RAA is also a requirement for any registrar that wants to offer new TLDs. So this was a big stick that ICANN used to push through the agreement. Folks who wanted to offer the new ones must be operating under 2013. I can still work with a registrar that's still under 2009 for .org, but I would not be able to work with them for 2013. It was supposed to bring in a greater element of consumer confidence for the protection measures to the market, that remains to be seen, but it is a requirement. I think I'll leave it there, covered.
Thank you very much, Michele and Paul, for giving us this basic lowdown on what the WHOIS system is, how it works, and the important distinctions that we must keep in mind while carrying forward this debate. Next, we have Monica Zaglianuriti. I'm sorry I massacred your last name, but please introduce yourself and the report that you have written on this issue.
Okay, thank you very much. Hello, everyone. Yeah, my surname is rather difficult. I'm Monica Zaglianuriti, but I'm a fellow at the Research Center for the Internet and Human Rights, and I participate on this panel and in IGF as a privacy expert for the Council of Europe. Today, I'm so happy to be invited also on this panel, and today I would like to briefly present you the Council of Europe report that has been recently released, which we wrote together with Thomas Schneider about ICANN's procedures and policies in the light of human rights and fundamental freedoms. Although the opinions expressed in this report are ours rather than representing the opinion of the 47 member states, but without going into too much detail, I would like to just briefly highlight maybe the main findings and main methodologies that we adopted to say that what we have now within ICANN from data protection perspective is very, very bad. So, as it was mentioned earlier, the register, the RAA, it was already explained what it is, was adopted with a very strong pressure and lobbying from the law enforcement agencies, and especially the Five Eyes intelligence agencies, and at the expense of the privacy considerations, we argue so. As you all know, after the contract has been terminated with the domain name owners, the data is personal data, a great variety of data is still kept for 2 years in order to have a potential access by the law enforcement agencies. And what we do with this information and these mechanisms with the ICANN, we try to examine them from the Council of Europe perspective. So this means that we only try to examine and highlight the issues that would be critical and relevant from the European perspective. That's why we examine mainly Strasbourg and Luxembourg's jurisprudence, and this leaves some of our American colleagues and colleagues from other countries quite unhappy. But nonetheless, this is the Council of Europe work, so that was our main goal. So we try to remind GAC members as well as other important stakeholders within ICANN that pretty much these rules do not really comply with any international data protection standards or the jurisprudence developed by these two important courts. And we try to highlight that there is this test developed in Strasbourg that any interference with privacy rights must be in accordance with the law, must have a legitimate aim, and must be proportionate. To start with, there seems to be no statute that would purport such retention of data. Thus, the first requirement of the test seems to fail. The second one is actually accepted as a legitimate aim, and we do not really dispute that. What we dispute is the proportionality and necessity in the democratic society. And here we bring into parallel the latest decision of the European Court of Justice. I'm sure you know about it. This is Digital Rights Ireland case where the data retention directive was invalidated because of its disproportionate effect on privacy rights, and we draw parallel to this, and we claim that this is very similar, and even if it would satisfy all the other requirements, this one would definitely fail, because 2 years after the contractual basis is no longer valid is rather disproportionate. And if the member states and the countries would like to have data retained for long periods, it is for them to actually enact the legislation that would stipulate this. So this would reflect the traditional jurisprudence developed in the Strasbourg court. And then we also applying just the very, very standard traditional data protection rules, which claims that there is a purpose limitation principle, which means that the data that is collected for one purpose cannot be used for another. And this is what we have in the ICANN RAA. Finally, we also have a look at the HOI's database, where third-party access is rather unlimited, and say that this is also not really in compliance with any international standards on data privacy. So I think I'll keep it short and give it to the other panelists, and maybe later we can have a discussion. But this was the idea, to highlight where maybe all the mechanisms and policies that are in place at the moment would not be in compliance with international law, and actually with the whole framework of European data protection. So thank you.
Thank you very much, Monica. If I could just ask you to briefly touch upon what third-party services, you mentioned that phrase, so...
Okay, so how it works is that in the HOI database, there is also a variety of data kept of the domain name owners, which is accessible to pretty much anyone because it's available online. And it goes into sharp contrast with the idea that third-party access needs to have a lot of safeguards in the data protection regime, at least in Europe. So in many cases, you either need to have a public office function to be able to do it for administrative purposes, or in other cases, you would need to have a court order to actually access the data kept by other organizations, or be that private or be that public. So this goes into very sharp contrast with this.
Thank you very much. Now, Richard, who's from Europol. Richard, do you agree with what Monica said about disproportionality?
Get right to the point.
I want to introduce myself. My name is Richard Leaning from, I'm the law enforcement officer from the UK, seconded to Europol and the European Cyber Crime Centre. And also one of the officers that put together the recommendations for the new RAA 2013. But our recommendations were just recommendations. And it was adopted by the ICANN community going through due process. So whatever's in the RAA 2013 was adopted by the community, not just by law enforcement pushing it. So we have to be quite careful on the words that we use. It's not law enforcement that said we would like, and it went through due process of the ICANN community, which is where we've got the RAA 2013. Regarding the privacy side, yeah, everyone's right to privacy. The problem that we have as law enforcement officers is that, let's just get, I am a cop, a street cop dealing with crime, all types of crime that has a presence on the internet. And the internet is either IP addresses or domain names. The problem that we have is identifying the people who have responsibility for domain names, because the who is at the moment is not accurate. And if I took it as face value, I would spend half my time in Disneyland looking for Mickey Mouse, because that is who's registered to the majority of the domain names. So we welcome this new process, what Michele and his team have done. So that there has to be a compromise between the needs. It's not just law enforcement, there's other actors out there that need accurate who is for a start. For consumer safety. I mean, there's loads of things out there that the public need to be safe about. So, yeah, I agree that maybe there's a pendulum, so I'm interested to have the thing. And also the thing is come here to understand what the concerns are from, so.
Could you give us a couple of examples of how whose data has been found useful in law enforcement, in cases, etc.?
It's been found useful because some of the The bad actors that we're looking at now started when the internet was very young, and they leave a trace because they didn't know how to wipe themselves clean from an early age. So there's always an email address somewhere in there that is good for us, or a telephone number, or a physical address, or a username. There's always something in there. But it proves the negative as well, because sometimes the domain names that, you can see a pattern of how they've been registered, where they've been registered, payment, and all this type of thing. So it's a useful tool. It's one of many tools that we use in our investigations, but it is just one. And if we can try and make that one a little bit more accurate, then it will help us in building up all our other avenues.
Sorry, and just one last question for you before we move on.
Yeah.
And if we had privacy proxies which allowed you to mask your identity while purchasing a domain name, and privacy proxies that accepted payments using bitcoins, say, would that, what is your opinion about that?
Well, that's going to be an issue, because the bottom line is we would like to know who has responsibility for that domain name. So if it is behind a proxy private service, then we'll go to that private proxy service and ask, if they have accurate data, which they probably don't, it depends. But the bottom line is that if you have a domain name, surely common sense suggests that someone must know who is responsible for that domain name.
Next up, we have Siora Nas, who's from the Article 29 working party, and I think we finally have a good debate going. Where do you stand on this debate?
Yes, thank you very much for having me. So I personally work for the Dutch Data Protection Authority, but I'm here to represent the Article 29 Working Party, which is the name of the collaboration of 28 individual data protection authorities in Europe. We write opinions, and we wrote a number of letters to ICANN regarding the RAA. Basically, I think my colleague from the Council of Europe summarized all of our criticism with regard to the data retention obligations in the RAA, namely that it's not proportionate and there's no lawful obligation, legal obligation for registrars to retain these data after the contract has been terminated. It's been a bit difficult to communicate with ICANN, it's been turned out to be difficult in general to discuss privacy issues with our US counterpartners because of a basic misunderstanding about the human rights value that we attach in Europe to privacy, as opposed to a more consumer approach in the US. So that's been difficult. We've sent this letter, 3 letters in total, saying that really, yes, all 28 data protection authorities in Europe think that all parties should get a general waiver from the new data retention obligation. With regard to the comments made by my colleague from Europol, if I may summarize your job as that, you mentioned there has to be a kind of a compromise, right? Police does need access to accurate data. But and the public needs to be safe, right? In my mind, you could compare that to the police innocently demanding for a curfew for everybody after 8 o'clock at night. That would definitely reduce the crime rate in a country, certainly after 8 o'clock in the evening, right? And it's not an innocent suggestion, actually, I would suggest. It is quite vital if law enforcement asks in a public governmental forum like ICANN for the need for data to be retained 2 years after termination of a contract. I do not find that an innocent suggestion in order for a general public need to be safe. I think the police itself should also take these fundamental human rights at heart and not propose such suggestions in the first place, but start with a far more proportionate proposal. So I think it is a measure that is way too broad and therefore disproportionate. And that is the opinion of the Article 29. Thank you.
could you also address how the differences between jurisdictions could be taken care of? Because if, for instance, a law was to be put in place, then it would have to be some kind of either national law or transnational law within a region like the EU. But that would still lead to differences, so how would that be taken care of?
Two short remarks. So first of all, data protection directive is already applicable across Europe. And as data protection authorities, we have reasoned and specified why this retention obligation is illegal across Europe. So that is current law. If member states would individually want to introduce a retention obligation, that would have to pass Parliament, but it also would have to pass this new very strict test decreed in April by the European Court of Justice, which says if government wants access for law enforcement purposes to data retained for or collected basically for commercial purposes, then there is a very strict proportionality test. That is this fundamental data retention ruling from the European Court of Justice, which Monica referred to. So after April, after this ruling, it will be very difficult for member states in Europe to pass new legislation introducing data retention obligations. Does that answer your question?
To an extent, yes. Next up, we have Stephanie Perrin. And Stephanie served on an expert working group that issued its final report on this and other aspects of WHOIS policy quite recently. And Stephanie also authored a dissenting note to that report. So Stephanie, could you please tell us more about that and whether you share the views of the European privacy advocates on this panel?
I think briefly, let me just give you my summary opinion of what's going on at ICANN. Many people have read Alice in Wonderland. There's a companion volume, Alice Through the Looking Glass. And I have to say, I was recruited from outside ICANN to come in as the privacy expert to the expert working group. This was an attempt to solve a 14-year struggle between the privacy advocates and the intellectual property and law enforcement advocates on the other side as to what goes in the WHOIS. Now, in Alice's Adventures Through the Looking Glass, I think it's more like, title doesn't matter. Basically, she's in a backwards world. And I found myself, after about 6 months, I'm busy doing a doctorate at the University of Toronto on why privacy isn't implemented. And I said to my thesis advisors, this is a fascinating problem at ICANN. I believe I'll move my dissertation topic over to why ICANN doesn't have privacy in WHOIS. And one of the central problems, and shamelessly I will say, if anybody has been watching ICANN and would like to be interviewed, I'd like to interview you. Things are backwards. If you are doing something in the public interest, analyzing the relevant laws in what it must be confessed that transborder data flow is a jurisdictional sinkhole into which one can fall. It has always been that way. It has been since the early 60s when we started to worry about transborder data flow. So for ICANN to just duck that problem and say, well, if you don't have a law, we're not going to apply it, and that law doesn't apply here because it's the state of California, and this contract, which we are making the registrars sign, is according to the laws of the state of California, that's not acceptable from a public policy perspective, in my view. Now, I did find myself on the experts working group, and it's disbanded now, so I don't speak at all as a member of the group except to regale you with my experiences, but I have been responsible for administering law inside a public organization, the Department of Communications, which deals with these kinds of issues, although it was so many years ago, it was before the internet. I have been responsible for crafting an international standard that Canada came out, a quality standard for privacy. Then we went on and developed a law. Then I worked in the private sector as a chief privacy officer. Then I worked in the Privacy Commissioner's office as an oversight officer. Now I'm looking at it theoretically as a pointy-headed PhD student. I take this kaleidoscopic view of what's going on at ICANN, and it's still backwards. I cannot find a lens where this makes sense or is acceptable. Now, that's a rather brash statement. We did some good things in the expert working group report. We said that where privacy law applied, it would apply to that individual. That individual could assert their rights. Unfortunately, and the reason why I issued a dissenting report, is we also put a clause in that said, in order to basically get a domain name registered, you consented to the use of the information. This is one of the fundamental problems in privacy, in a narrow look at privacy legislation. Legislation that doesn't necessarily focus enough on proportionality and purpose and back it with human rights and have mechanisms to stop coerced consent. So that if you put that kind of clause in, no matter in Canada, for instance, with the law that I'm most familiar with, I could sign away my rights. So to say that privacy law applied so we're okay doesn't work anymore. You've just signed away your rights. So that was why I dissented. It was that one clause that triggered it. There are a number of other things that are very difficult to put in practice from a practical, and that's really the lens that I take to these things, from a pragmatic implementation perspective in the report. The one thing that I think is really useful and a step forward and also difficult to enforce is the concept that you have a right to have an anonymous domain registration for purposes of free speech, protection of people who are at risk, and there are all kinds of people at risk if their location is found. I think that I'd surely like to continue to try to work on that project. So ICANN has created a beast. I'm now hanging around and volunteering my time.
Excellent. Could you, Stephanie, also say a little bit about the recommendations and specifically what happens if someone just goes and registers a domain name under a fake name? What kinds of liability mechanisms arise, and what responsibilities lie on registrars?
Well, that's really more of a question for Michele. I can tell you that as the privacy advocate here, we have a lot of sympathy for that as a problem, particularly if it's my name that somebody's registering as a fake name on their criminal website. There is no reason for law enforcement and privacy and the privacy nut to be at other ends of the table on this. I think we're very aligned on many, many issues. I would totally agree that the data retention is disproportionate, and the data retention doesn't necessarily catch the guy using the fake name, taking my name. It's no good. I would like to see, having worked in government, I want to see the actual results of the risk mitigations that we put in place. And if we measure the results, how many times that escrow data has actually been useful for the purposes that are cited? I'm sure it's useful for intelligence, but intelligence is not one of the stated purposes. You know, criminal investigation is supposed to be why you're escrowing that data. And I would like to see the reason for some of the metadata that they're collecting. Now, as an if I may go on a rant here, and please interrupt me with questions, but as an individual out there, when you register your domain name, do you have a clue that the metadata that about your transactions with your registrar is being gathered? You don't even know what that metadata might be. You know, you assume when you see something, oh, well, it must be something to do with a root server. Please don't explain it to me. I don't want to know. But these things are really important from a criminal investigation. As I always used to say, if it's good enough to get the FBI at my door, I want to know about it, you know? Anyway, inadequate explanation of what the data is being collected for and used for.
Thank you very much, Stephanie. Next, we have Joy Liddicoat from the Association for Progressive Communications. Amongst the many, many hats that Joy wears as a lawyer, she's also on the board of Internet NZ, which manages the .nz CCTLD, and CCTLDs have been conspicuous by their absence in this discussion because most of ICANN's policies don't directly apply to them. So, but privacy concerns still arise. So, Joy, could you give us some perspectives on that?
Sure, thank you. Yeah, a few remarks by way of background and then perhaps sort of critical reflection. In the .nz CCTLD space, we, harking back to the RFCs which created it, .nz was originally run out of Waikato University when a few geeks with computers thought, maybe somebody might want to use this thing called this domain name space. This was back in the 1980s, and then gradually the amount of uptake and registrations started to escalate, and this responsibility was handed or entrusted to a new organisation called Internet NZ. And so we manage the delegation in Internet NZ. We have a separate substructure which that delegation is further delegated to the Domain Name Commission Limited, and it's the body which sets the policies for domain name registration, registrar accreditation, WHOIS policy, privacy policy, and so on in that country code space. I was on the board of that subcommittee, but I've just been elected Vice President of Internet NZ, so I've moved off that board. So it's sort of through this window that we look at what's going on in ICANN and struggle. We struggle a lot. We have some of the same systems for accreditation of registrars. We have a registrar accreditation agreement. We actually also have a subsidiary which runs the registry. And which, and from our perspective, the WHOIS database was really originally created out of a sense of responsibility for transparency. In other words, here we were managing this public resource, and we wanted to have in the domain information about who these domain name holders were, because that's also one of our obligations under the RFC 1591 and related standards. And for sure, we weren't really, back in the 1980s, really thinking about privacy in the way that we are now. However, we have developed privacy-related policies. We periodically check the WHOIS database for accuracy and have been known to request registrars where we have concerns to make sure that the veracity of their data is, as accurate as it can be. But we're fortunate in that space because we have very strong national legislation on privacy and an exceptionally competent privacy commissioner, John Edwards, who's very familiar with the topics and interested. So we don't suffer from the same problematic nature of which privacy standard to apply, because we aren't bound by ICANN commitments. We have a letter of agreement with ICANN recognising our role as a CCTLD operator. But I do foresee that we're going to run into problems because increasingly in the CCTLD space we see ICANN accredited registrars wanting to offer services in the CCTLD space and being accredited as registrars. And we've got something like more than 70 registrars accredited in our CCTLD, which I think is amazing given there are only about 80 people living in New Zealand. But still, and we're recently opening up the second level domain in .nz so that you can register directly there, and that's also generating interest in this space. So I do think we're looking at ICANN policy in this critically, we're not comfortable with how the registrar accreditation agreement was negotiated. Definitely, we were non-commercial users were definitely concerned about the backdoor negotiations and the in-secret negotiations that happened around accreditation agreements. We don't do that as a CCTLD. We publish the registrar accreditation agreement with proposed changes for people to see and comment on. So I think that there's been some flaws, deep flaws in the ICANN process, which maybe some lessons that could have learned from a few CCTLDs about how to do this. So I'll end my remarks there.
Thank you. Now I'd like to open up the panel list to ask each other questions, and along with that, if folks in the audience have questions and remote participants have questions, could you start formulating them so that we can get to you soon? Would any of the panelists have rebuttals or further questions for each other? Because I have a few for you.
I feel understand that even though we're sat at the further end of the tables, that we're actually quite close in what we want and would like. Regarding the RAA, our engagement of ICANN was with the rules that were in place at the time. We don't make the rules, we just played by the rules that we all told. So we didn't have any secret meetings or underhand discussions, we just did through our GACs put our recommendations forward, and they were accepted through the processes of ICANN. The bit I'm interested in is about, in a criminal investigation, you're quite right, maybe we should be starting to evidence why who is helpful in our investigations or unhelpful in our investigations, the case may be. The bit I'm interested in is if you're saying that as soon as the contract's been terminated, are you saying that all information should then be deleted? Or where do we... I'm unsure what you mean by that.
Okay, so in our letters, the working party specified that communication details to store those 6 months up to 2 years after the contract has been terminated, there is no legal ground. But of course, fiscal legislation may apply in different member states that requires, for example, the fact that a transaction has occurred may be stored for up to 7 years. As far as I know, in the Netherlands, it differs per member state. So there's always going to be some trace of a financial transaction. But these communication details you mentioned as well, like email addresses and phone numbers and nicknames and Skype names and whatever, they just should be deleted immediately according to data protection law the minute the account is terminated, and in some cases even earlier. If you have an account during 10 years, an agreement for a period of 10 years for a .com domain, it is not very compliant with data protection law to store the original IP address for a period of 10 years. That would be excessive. So it depends on the circumstance, but it won't be the case that data protection law requires all data to be deleted immediately. It is a balancing act. Which data are no longer necessary to fulfill the contract?
Sure, and Stephanie, I have one additional question to you, so if you could address both this issue and that question. It's that free speech, you said the freedom of expression leads to a desire for anonymity, that it's necessary at times to be able to express yourself freely. And this has indeed been recognized by the Supreme Court of Canada as well in a recent judgment. But when there's such a great amount of choice out there, when it's not just GTLDs that you can register, that you can buy, when you can go to various CCTLDs which gather varying levels of data, and too many of which aren't very, don't really check the data that is input, and for reasons of practicality. So when you can pseudonymously register on various CCTLDs and actually use that to put forward your ideas pseudonymously, what really is the problem with ICANN policies for a few GTLDs?
I think there's a fundamental problem that the backwards problem is that there is no basic policy of what is in the public interest, what data should be collected, and what those purposes are. They have to be legitimate, they have to be proportionate. So what we have now is a very weird silo effect throughout ICANN, not just in the applications. As a simple registrant, and I've worked in this business all my career in IT, and I call myself simple because I would not know that the CCLTDs would be a better place to register if I wanted my data not escrowed. How the heck would I know that? And do I have to go to that level of investigation of what is becoming a necessity of life to have a domain? I don't think so. I don't think that's acceptable. I think the onus is on ICANN to harmonize its policies to a higher level, not to the lowest level, not to the lowest common denominator, but to the highest level. And so, absent that policy, we have this weird effect going on where different stakeholders are doing, and different registries are doing different things.
But couldn't some CCTLDs emerge as, paragons of free speech, like say Canada or Iceland or other countries which are trying to promote that reputation?
But if you're not an aficionado of the IGF or ICANN, and God help me, I wish I weren't sometimes when I'm at ICANN, you wouldn't know that, would you? If you're lost in a village in a country in the heart of Africa and you don't get access to the wondrous Canadian privacy-enhancing domain registrars, how would you know? I don't think that's a good approach from a sound policy perspective. So, the point that I raised my hand about was these constitutional cases, and it speaks to this whole issue of not having a sound policy. So we just had a Supreme Court case, finally, after 16 years, throw out a provision of the law in Canada that was excessive, that allowed police to get access to telecom information and ISP information and, of course, registrar information without a warrant. We've got no objection to police going in and getting information, but let's have a process, because if you don't have a process, you will have abuse. Period. End of statement. And the police have as much to lose from abuse, because when the abuse is discovered, then they can't do their legitimate business. That's why you have procedures, to make sure that everything runs correctly. So, and the warrant procedure need not be burdensome and need not take time. And it also covers the registrars who are being served these things. They too have abuse problems. And when you have backdoor pipes going into registrars that the population doesn't know about, then you've opened up a security hole for somebody else to get in there. So that's the kind of fight that we have going on here, and I never thought I'd hear myself saying we need better procedure, but that's what we need in this area, and it has to be backed by sound policy.
Excellent. Sure. The one last question I'll try and get some opinions on in this would be about privacy proxy services. So Paul, .ngo as a trusted GTLD is planning on not allowing for proxy services. Could you explain the rationale to that? And then I'd want one of the panelists to respond to PIR's decision.
Sure. So let me just step back. In .org, as it currently exists, privacy proxy is absolutely allowed. With NGO, which is not in the marketplace yet, it's still forthcoming, as a new TLD, we can set any policies we desire. All of it's been communicated in our application and coordinated with the community. And what became clear to us as Public Interest Registry, engaging in the not-for-profit NGO community over a good 4+ years now, is to address their needs, their pain points, and the most important is being found. Because once they're found, they can begin to collaborate online. Very importantly, they can bring attention to their cause to help generate donations. Finances are always so very important for not-for-profits. So we decided as a matter of policy that we would not have privacy or a proxy service allowed in NGO, that the information that a registrant puts into who is for NGO or ONG must be their own. Certainly it's a delicate decision, and it was not taken lightly. Given the mission of many of these groups, one can imagine our response to those who say, well, they should be able to mask their identity. They have a choice. The choice is .org. But for the value, the benefit that NGO will bring, having or not having anonymity, not having privacy proxy, didn't make sense for that particular namespace. But again, it is our unique environment or situation. It's not necessarily applicable to other TLDs.
And .ngo also has further information apart from whois, right? There's the directory services apart from whois. Is that compulsory? Is that or could an NGO say we don't want to go in for that additional, which I recognize has additional payment?
Sure. I don't want this to turn into a sales pitch for NGO, but the directory, your profile page, think of it akin to like a Facebook page. There's very basic contact information that's there. It's the kind of information that any entity would want to put on a basic website. That's really what it is, a basic one-page website.
Okay, any responses to that before we go first to the remote participants and then to the rest of the audience? Kelly?
Yeah, try and get the microphone to work would help. No, just responding to Paul sort of, kind of indirectly. The ICANN does have some processes around policy development. With respect to whois, however, for a variety of historical reasons, they tend to be rather broken.
Backwards is the word.
Stephanie, calm down. Stephanie and I spent the last 18 months together on the EWG, so we're both overly familiar with ourselves at this stage. At present, the default is public display of all contact data. And the thing is that people should not conflate and confuse the collection and the display. I mean, they're two separate things. Now, law enforcement, I will of course rip into him as much as possible, but I do honestly see that he needs to have access to accurate data for dealing with crime, and that we can't avoid that. That's a reality. But there is what I don't understand, I fail to understand, and I really find completely disingenuous from those who keep on pushing for this fully public publishing of data. I just don't understand the logic behind it. Now, law enforcement, real police, these agents of states, those states to whom we pay our taxes, etc., guardians of our safety, etc., they have legitimate reasons, legitimate rights to access data. Of course, within certain bounds, they can't go off just, pulling out our data just for laughs. But, they have a reason to do that. The problem we're finding is that in this space, there are lots of other third parties, primarily IP lawyers, sorry, somebody had to say it, who want to have access to everybody's data so they can protect their trademarks, so they can protect their interests, which are primarily commercial. And they want everything to be fully public because they don't have a legitimate right to gain access to the private details. And I've said this in the past in various fora, and I'll say it again, there's an overloading of the whois. It's being used for purposes for which it was never intended. There are lots of third parties trying to to repurpose the data that's been provided. Like, if I want to register a domain name, I have to provide details. I give up certain rights, and I'm perfectly happy with that. But that does not mean that I'm giving my data to some random American company, not ICANN in this specific purpose, to go off and sell that data to third parties purportedly to protect consumer interests.
Thank you, Michele. That's very helpful. And I won't take the IP lawyer as a slight against me. I think of myself as an access to knowledge lawyer.
You're all evil.
So, are there any remote participant questions so far? Thank you. Any audience questions? Please raise your hands. First. And please also introduce yourself.
Yeah, so I'm Alex from Privacy International. I just had two comments. One for Richard Leaning from Interpol. I think if people had better guarantees about their data not being accessed by third parties and used for unintended purposes, people might be a bit more honest about the information they share. So that's maybe something to think about the effectiveness and trying to have an accurate database. If people had more guarantees, they might be more honest in that process. The second was on the last point about the state being guardians and there to protect us. Unfortunately, states have gone well beyond what's been given to them by law to protect us. And they've gone beyond what the law tells them they can do and the rights that we as citizens to some extent are willing to sacrifice for our security. And unless that trust is reinstored, I think people are not going to believe them anymore.
I'll take a couple more questions and then come back to the panel.
Okay, take this mic, this is on. Hi, hello, my name is Monica Armand, I'm a journalist. Thanks for the discussion, and I would like to challenge you. Why has this discussion not taken place like 5 years ago in the Governmental Advisory Committee of ICANN, where a data protection official could have challenged, like we heard it today, the law enforcement side about their requests, what they want to have from the WHOIS, because we never had that, and that partly I think resulted in the whole mess that we saw over the years. So my question, actually my positive question would be, will the Article 29 group make an effort to be at the next ICANN meeting? Because I understand WHOIS will be a major topic there. And also the extended versions of WHOIS. And then I would like to challenge Mr. Leaning. You said there have been no secret meetings, which is not true. I mean, even at the ICANN meetings, there were closed meetings of law enforcement. For some ICANN meetings, it was like for 3 or 4 days. I don't know what you did there, because it was closed. But I know that papers came out with data retention provisions that went far beyond what we see now.
Okay, and I'll take one more.
Hi, good afternoon. My name is Rafał Trzaskowski. I'm a Minister of Digitalization and Administration of Poland. And I'm responsible for squaring the circle that you've just mentioned, especially when it comes to the retention directive after the ECJ's ruling. And obviously, I mean, this has much broader implications also when it comes to the question that you are actually addressing when it comes to ICANN. But I would like you to be a little bit more specific, because and maybe help me out how to actually square that circle and do the balancing act. Because I agree 100% with you that after the ECJ's ruling, it will be quite difficult. But now, enforcement agencies, also in my country, say only the status quo allowed us actually, to pursue the criminals and so on and so forth, whereas privacy advocates are saying, well, I mean, definitely the status quo is, cannot be actually sustained, also in the view of the ECJ's ruling. First of all, when it comes to proportionality, I mean, it seems for me absolutely clear that retention has been in certain cases abused, because certain types of crimes have to be specified, really serious crimes, as opposed to crimes which do not necessitate these sort of measures. And I think I've heard that the German government, is trying to square the circle by simply stating that, first of all, there will be some very serious crimes clearly specified, and then there will be no retention across the board. But if the authorities have legitimate concerns, they can ask, for example, for certain data to be retained up until the moment when there is a court order to actually release them. And I wanted to ask you about the parallel to the whole problem of who is and so on and so forth, especially you representing the group of Article 29 and the gentleman from Europol. Would that be a direction to actually square the circle? To really specify, to really look at proportionality and to look at ways which would actually give us a little bit more flexibility, but at the same time guarantees that that retention will not be abused. Thanks.
Excellent. And if I may just add one thing to that is when mutual legal assistance treaties, MLATs, have to quite an extent been an abject failure, how do we say, for instance, if there is a court warrant that comes out from India and the registrar is located in the US, then how do we actually get that process to work, which you're describing? So some of the panelists have now specific questions, but I'll start from this side, and once we're through, I'll come back to the audience for more questions.
Use this one. Can I just respond to that last question? If we did a really good analysis of the use of the data, understanding, of course, that this is going to probably be not available to journalists, we need to know what kind of investigations actually need two-year-old data, escrowed data. Bearing in mind that the site is down and it's dead, there's no relationship with the registrar anymore.
Sorry, just one thing, Stephanie, just to interrupt you. Please don't say escrowed, because escrow is different within the ICANN context. Stored, retained. This is because we, as registrars, escrow to Iron Mountain.
Right.
But that's just the registration data.
Okay. So yes, thank you for that. This is what living at ICANN is like, folks, just in case you were thinking of signing up. It's always more complicated than it looks. We need to understand what kinds of investigations this is useful for, because there is this thing called a data preservation order. If you are doing a long-term investigation of a whole network of fishy-looking sites, I don't mean that in the but the fishing, you know what I mean, anti-phishing working group, that kind of thing. You can slap a preservation order on that. So you don't need to, as my colleague explained, you don't need to grab the data of every poor little grandmother who's got a website for the pictures of her grandchildren up, So I really think that a use research project, and that has to be updated all the time. It's not the same as it was 15 years ago when all this started to roll downhill. To see what needs to be done, should be done, and that'll help you square the circle, because data preservation would solve a lot of your problems.
So to just respond to the call, why didn't the Article 29 Working Party intervene 5 years ago when this process started to be developed? We did, actually. We wrote an opinion in 2003 and wrote letters in 2006 and 2007, just for the record.
And
we were aware.
And who were these letters sent to, ICANN or the GAC?
Well, GAC is, of course, a committee within ICANN. We prefer to address, like, the CEO of ICANN, because we think it's more efficient to go to the top level than... but it is indeed a problem that GAC, government representatives from the member states, maybe were a bit more or better informed, let's be subtle, by the law enforcement demands than by the data protection demands. And of course, in 2005, the world looked completely different, and law enforcement indeed had a a voice that was much more heard than data protection. Data protection was basically considered a hiding for all the evil in the world. And now the tide has turned, and I think data protection concerns are much better heard, and especially with such a ruling from the European Court of Justice, which is irrepealable. It's the end verdict. It's just not permitted. It's disproportionate. Governments may not introduce such data retention legislation light-heartedly. And that is the other thing from the Polish representative that asked for, isn't there some kind of arrangement you can think of from a data protection point of view to combat serious crimes, right? Can I summarize your question like that? And I do agree with Stephanie Perrin that there is an alternative, which has often been argued for by the Article 29 Working Party, which is the quick freeze or the preservation. And of course, given the necessity of a case is convincing, yes, you may preserve a lot of ongoing data in an ongoing investigation. The problem we've seen in Europe for the past 6 years after the introduction of the data retention legislation is that there has been no convincing evidence that it has actually contributed in a proportionate way to the fighting of serious crime. The European Commission has sent questionnaire after questionnaire to the member states, and all the member states came up with is horrific examples, right, of child pornography, kidnapping. And when we look closely at these examples, a lot of these cases could have been solved by starting within that investigation by asking for the available data that were available anyway. Cases of kidnapping, you don't wait for 2 years of asking who called the mobile phone number of the disappeared child, right? So we were shocked to see that this was management by speech and by horrific speech, which we all abhor, right, these cases. And now it's time to come up with real evidence, like Stephanie said. Thank you.
If I can add and top up on this, why we didn't have these meetings and these talks 5 years ago or back in 2005, I just would like to say, I guess, that we have a different rules of the game now since all the Snowden revelations, and I think that the privacy is gaining much more teeth on international level now, and it is also demonstrated by the fact that we have this is not the first meeting on ICANN and privacy policies here in IGF. And like Stephanie said, she's been working on this 14 years and nobody has really listened to her. But I think in ICANN, highlighting these privacy issues, and I think that's the duty of us, not as privacy geeks or not as privacy advocates, but just as citizens of the world to actually push this further, because there will hardly be any better moment for actually having a leverage rather than just now. So I hope you all hear me and are with me.
The struggle's gone on for 14 years. I've only been working on it at ICANN for 1.5 years. I don't think I could take 14 years, you know. This is, I want to get something done and fast. But I can tell you why nothing has happened from the other side, from civil society's side. I should wait until my research is done. But my experience as someone volunteering my time, while there are the best intellectual property lawyers around sitting across the table from me and they're getting paid, meantime, and this is not me whining about my expenses not being paid from 1 year ago, it's me whining about a structural deficit within ICANN. The folks that are there to represent civil society have umpteen things that they're looking at, free speech, all the other processes, to get the deep expertise that you need to combat all of the other arguments. Somebody's got to volunteer their time. And high-priced human rights lawyers aren't willing to do that, especially when it costs them money to come. Yeah. That's a problem.
Could we have Richard also responding?
I don't know where to start in my big list of answers. Yes, to the journalists, law enforcement have law enforcement days at ICANN, and they have been closed. They've only been closed is because it is basically a training day where internet experts basically telling us and some of our colleagues how the internet works. So at ICANN, everyone goes to ICANN from the internet. So they're telling how the domain name system works, they're telling us how the IPv4 to transition to 6 works. That is it. It's a training day where experts come to us and build our capability in how the internet works. That is it. There's no underhand dealing, there's no secret stuff. I mean, common sense would suggest if law enforcement are going to have some sort of secret meeting with ICANN, would we put it in the agenda of the ICANN? Really? And say, look, we're in this room and it's all secret, but we're letting everyone know that we're there. Really? You know, I know some cops are dumb, but we're not that dumb. Okay? So, in London, we actually opened it up for the morning session, and we had a great crowd turn up, and by half an hour everyone was bored and they all walked out. So it'll be open again in LA. Please come and see what we talk about. I can guarantee you'll be bored because it's basic stuff to cops on the streets that do not know anything about the internet.
Sorry, Richard, just if you don't mind me adding, I've attended some of these ones. It's called operational security. There are no secret handshakes. I've been in the room several times. It's really down to helping law enforcement get a better grip on the technical realities, explaining to them how the ICANN policies and processes work. I think the reason that they've been closed, there's a multitude of reasons for that, but just because a meeting is closed doesn't mean that the people in the room are coming up with crazy conspiracies. I mean, I'd love it if it was that interesting, but honestly, it's not.
We've listened to the criticism because it's not the first ones to mention closed, and that's why we're not putting it on there as closed. It's going to be open. So, you know, please come along in LA. I think it's Tuesday this time that we have it. So please, I'll buy you a cup of coffee and we can have a chat. Regarding our investigations, to answer some of our, we use many techniques, many different things about investigations. I could go on for days about the complexity of a criminal investigation. Some of the things you've said, yeah, I mean, we may have to go back 2 years because, which may sound strange, because the defence have asked us to do something to prove or disprove something that their client has done. It may not be on our, you know, as you very well know, there's a legal system and we have to play by that legal system. So sometimes we have to go back because the defence have asked us to go back, not because the prosecution want. But it is very complicated. I won't go into too much detail. The thing about the who is that law enforcement didn't invent the who is. The who is was there. And if ICANN and the registrars and registries are going to have the who is, let's make it accurate. Otherwise, let's not have it. I mean, you've got it. And all we're saying is, well, you've got it. It's meant to identify the people responsible for the domains. Well, let's make it accurate, otherwise what's the point of having it? And that's all. We didn't invent the who is, it's there. And our suggestion was, well, if you're going to make the effort of getting those details, do you not really think that Mickey Mouse from Fantasyland is not the right details? That's all we're asking. You know, validate, verify who is on the who is if you're going to have a who is. Now, do we need a who is? Should the registrars take more responsibility about who it is that the domains are registered to and we just go to the registrars? Law enforcement doesn't. We don't mind. We don't mind where the information is, as long as it's there and it's accurate and we can go through a due process with the necessary safeguards to get that information. So that's, you know, basically all I have to say on it. I mean,
thank you. So we'll take two more questions, and we have 8 more minutes, so we'll do them rapid. We'll take these questions, get them answered, and do one rapid-fire round of closing comments.
Hi, David Viorst with ISOC DC. And my question for you guys is, do you see any countervailing public right or public need to know who registers a domain to, you know, balance against privacy concerns? Should I be able to know who's publishing bad stuff about me? And if so, how would you balance those two things?
Is it on? Thank you. Hi, my name's Chris Lahat. I'm the ICANN Ombudsman. I appear to have become almost by default in charge of privacy issues within ICANN, but there are two issues for me, and this is really a request for information as much as anything else. There's privacy within ICANN, which is its own topic, and I do in fact get complaints from time to time about the privacy of information which is provided to ICANN for various purposes and the use that's made of it. So it's not an academic interest. I really want to know some of the answers, and my view is that our policy within ICANN definitely needs attention and revision because it would make my job a bit easier, among other things. The policy outside ICANN, if you can say outside the ICANN community, is a much bigger issue, and the cross-border issues I don't think have been touched on too much. But one of the fundamental problems we have at ICANN is that we don't have any, if you like, founding constitutional document. We have a set of bylaws which are based on Californian law, but I'd venture to suggest, and this is probably better said as a personal opinion, that we've moved beyond the need for a United States-based constitutional or founding document, and we need something that's deeper. And within that, that means that such a document would, of course, like any constitutional documents, deal with issues like privacy, which means that when you sign up for using ICANN in whatever sense, then you're going to buy into those fundamental principles, which are, in effect, a form of human rights. So I think we've got to think in a bigger sense about how we're going to solve some of those cross-border issues, and I just throw that in just to add discussion.
Thank you. And I'll take one quick last question.
Hi, my name is Nehashish. I'm from National Internet Exchange of India. This is regarding the GNSO Council initial report with regard to the UDRP process, specifically on locking and cyber flight. Is that audible now? Yes. So when who is looked at, it's specifically looked at to follow the due process, whereas notice could be sent. Whereas this particular initial report proposes that the lock-in should be put, there should be lock-in on between the registrar and the registrant to ensure that there is no cyber flight. So in that context, how important WHOIS database becomes and whether it is relevant at all, because you are totally subverting the whole notice procedure which is in place. So how would you respond to that? Thank you.
A number of questions, including would ICANN be better off as a Geneva organization, perhaps? And I'll just allow all. Actually, I think we should start off with the rapid fire and closing statements. And if you could have your responses as well as part of that. Let's start from this side.
From our side, it's interesting. Even though we may come from different places, we all want the same. We want the internet to be a safe place for the community and end users to use without being victims of crime every single time they log on. And how we get there, there's a long journey to travel. I mean, obviously, we can't be naive to think there will never be crime on the internet. It will be crime on the internet until the internet finally dies long after I've gone, as there is crime in the real world. It's how we manage that crime and prevent, disrupt, and when people are victims of crime, law enforcement, no matter where they are, have a chance of finding the person who's responsible or persons who are responsible. If you go into the basic of the internet, it's IP addresses and domain names. That is the internet. So if people go through the trouble of registering who has a domain name, always saying this, if we're going to do that, let's make that accurate. For however long we keep it or what we do with it, but let's make it accurate. That's all we basically would like to see.
Thanks, Paul. And could all the panelists keep their remarks to around 45 seconds, please?
Sure, I can make it very quick. It's unfortunate that we are running out of time because some of the questions that were asked at the end, and in particular Chris's point that he raised about the need to focus on the transnational nature of a lot of these questions or issues. The leadership that we see in Europe in particular around privacy protection, privacy rights, is not necessarily the experience elsewhere. And for an organization like mine that operates, we may be US-based, but we operate globally. The majority of our registrants are from anywhere other than the United States. It's difficult to find that balance. And unfortunately, because it's such a complex issue, that's why we've been having a who is debate for 14 bloody years with no end in sight. These are not easy, these are not simple questions. Finding common denominators, whether it's the highest or the lowest, even that is difficult. So my expectation is that we'll continue to debate these things and maybe we'll be back here next year.
I hope so.
I would like to highlight perhaps a positive dimension, because as far as I understand, the Human Rights Council is also having a meeting next week on the importance of privacy in the digital age. I just would like to say that I think there haven't been a better moment since we have all these important judgments on the importance of privacy, all these different reports by Frank LaRue, and now the report by the Commission on Human Rights on the importance of privacy in digital age. We have the Google ruling, we have the Digital Ireland's ruling, Digital Rights Ireland, and the General Assembly resolution. And I think that this is the broad reason why we have these discussions now and here, is that because that the leverage is slightly changed, and now civil society and us as the citizens have slightly more power than we used to have. Maybe our voice may be heard. So I leave you with this positive note that I hope that in LA, ICANN 51, it will be discussed and open more to more participants to intervene with their opinions and views on this, and the privacy will gain more teeth within ICANN as well. Thank you.
Thank you. Joy? You've been waiting quite a while, sorry.
Thanks. Just a couple of practical suggestions for some recommendations. One is that certainly at CCTLD level, what we've done is worked actively with law enforcement in light of our privacy policies to do things like give them sorry, don't take that off my 47 seconds, is to give them wordings for warrants. So if they want a warrant to search for specific information, rather than go off to the court and end up with the wrong pleading, we help them shape the precise wording they need in order to access either WHOIS data or registrar information. We've worked collaboratively with registrars and civil society groups on that. So maybe it's time for this kind of thing to happen in the ICANN space, where the law enforcement workshops are opened up and turned into some practical sessions to assist in bringing in some of the expertise that's there, so that we move beyond this issue of until we get a more defined and clearer rationality to the privacy policy. There's some practical things we can do in the meantime.
Thank you. And Michele, and could you also mention how, if any of the folks here want to join ICANN processes, briefly, how they can do that?
Yeah, well, the barrier to entry to getting involved with ICANN stuff is really, really, really high. I mean, it's so hard. You just turn up. If you're interested in influencing this, please do turn up. It's not hard. If you're having difficulty, if you're finding it confusing, speak to one of us. There's charming ICANN staffers floating around the IGF who are more than happy to give you their business cards. A couple of comments just on some things that were raised during this session. I think it's an interesting session. Unfortunately, the time limit's not particularly helpful. Hopefully there'll be further discussion and debate. It'd be great to see Article 29 and others actively engaging again in the future. I know they've done it in the past, and I know that ICANN has had terrible difficulty understanding simple, clear sentences and words in English, but you know. Thanks, Chris, for your comments on the privacy stuff. In the EWG report, one of the things that we did say was that we felt strongly that ICANN needed to address it. I mean, in simple terms, if a company as small as mine has to address it, oh, for God's sake, I think ICANN can do so too. Having a proper privacy policy for the organization, having proper policies to deal with privacy overall would be helpful. I don't see why on earth registrars and others have to get embroiled in long, protracted, expensive legal battles to be able to actually comply with their own laws. To the gentleman's question down the back about the UDRP lock and who is, have a look at the UDRP process. Essentially, the who is data has to be confirmed as part of the initial triggering of the UDRP when it's tied up with pendency, not my choice of words, to do with UDRP, and as the registrar we have to tell WIPO or whoever who the domain name is registered to at that time, and the only information that we would have would be who is. Thanks.
Thanks, Michele. Shura?
I'll skip my 45 seconds to give Stephanie the floor.
Very kind. Thank you. In answer to Chris's question, if we had a privacy policy, and NCSG has a draft privacy policy that we are proposing to offer to the board. It won't be complete, but at least it'll sketch out where the huge holes are and what we need to do. Ancillary to a privacy policy would be a very useful working tool called a privacy impact assessment that would then take each policy initiative. That's one of the problems is you're busy working over here where the thick whiz guys, whoever they are, but they're mostly technical, are working over there creating something that abrogates your policy. So if we had a privacy impact assessment that you could apply in all of these working groups, then you wouldn't be able to come out with something before you saw whether it would match the policy, because what happens now is the reverse, the backwards problem. I've talked enough, but I'd be happy to answer any questions if people have them afterwards. Thanks.
Since we started late, I think we're ending on time. I'd like to thank the co-sponsors of this workshop, Council of Europe, the Federal Office of Communication of Switzerland, ICANN's non-commercial stakeholders group, the Yale Information Society Project, and most of all, IP Justice and Robin Gross, and all the panelists. Could we please have a round of applause for them?